and welcome to Be Informed. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to their elders, past and present. Today's topic is on employee rights, and we are joined by Paul Cott, a friend of Be Informed. He's the principal of Law and Lydiard in Ballarat. And we'll be looking at the topic today of requesting flexible work arrangements in Australia. So the information in this session today is general only. So if you do have any specific queries about your circumstances, you're an employee or an employer, you should consider getting specific legal advice. And the information in today's session is current as of today. Now, given the nature of law, you need to ensure that if you do rely on this information in the future, whether it's still current and suitable for you. So always do check with a legal advisor if you do wish to rely on this information in the future to ensure that it's still applicable. From a housekeeping perspective, the session will run with a 25-minute seminar, followed by Q&A. And there's also a one-page handout that Paul has prepared, which I will share with registered participants by email. And during the Q&A session, sorry, I forgot to mention, if you do have a question, please raise them to me in the chat function, and I will relay them to Paul for him to answer. So we'll now get into the seminar. I'll hand over to Paul, and we'll get going. Over to you, Paul.
Yeah, thanks, Carl, and thanks for inviting me to present again. I think this is probably maybe the 6th or the 7th presentation that you've invited me to, so I appreciate it. And they have been on other areas of law, but besides employment law, but tonight is squarely visiting the area of employment law, but in particular flexible work requests or requesting flexible work requests in Australia. Just before we get to the first slide, the right to request flexible work is actually a legally protected right in Australia. It's not a legally protected right to have the request granted, but it is a right to ask for one. And under the Fair Work Act process, that is, of course, that's what this is all about. As I mentioned, if we want to get to the first slide, anybody can make a request to have some flexible work. Obviously, the most important one, or the one that most commonly people know about, is the request to work from home. I'm not going to discuss tonight the right to work from home, which is going to be enshrined in legislation in Victoria, which is quite controversial. I'm not going to discuss that. That is just in relation to working from home. Flexible work requests are wider than just working from home. So as we say there are eligibility requirements, so that not just any employee can request flexible work and have the statutory protection under the Fair Work Act. So basically all employees can, as long as they have at least 12 months service. If you're a casual though, you have to have 12 months service with that employer, as well as have an ongoing expectation of continuing regular work. So basically they have to be working regular shift hours, almost like a full-time employee, but still be casual. And as the slide says, the employer has discretion whether to approve the request. And on the last slide, we'll talk about the refusals. So they cannot refuse for any reason, but we'll get to that shortly. So as I said, the right to request flexible work is under the Fair Work Act, and you cannot suffer discrimination as well for making a flexible work request. That's actually illegal, and it's a protected attribute under discrimination law. So an employer can't say, well, because you made that flexible work request, you've inconvenienced the business, therefore we're going to take some sort of detrimental action against you. Informal requests can be made, which sits outside what we're talking about tonight entirely. Anybody can ask for some sort of flexible work arrangement verbally, but what we're talking about tonight is flexible work requests in writing. So the request, though, does need to be tied to an eligible circumstance. So again, there is an eligibility requirement, and in that way, not all employees, again, can make a request. So it has to be tied to either the worker being pregnant, being a carer of a school-age or younger child, the employee having a disability, the employee being aged 55 years of age or older, and family or domestic violence or caring for someone experiencing family domestic violence, which obviously backs up the law around family and domestic violence leave. So they're the eligibility requirements before somebody can even make a request, which obviously have to be in writing. So we'll go on to the next slide. And as it says, the request has to be in writing. There's no set form. There's no set form of words or how you have to set it out, but you do have to set out certain things. So as we say, they're a verbal or an informal request, which is really a verbal request, gains no protection under the laws that we're talking about tonight. So the request must set out exactly the arrangement that's being sought and the reasons for the request, which have to be, as I said, tied to either carer responsibilities, disability, age, pregnancy, family or domestic violence circumstances in the employee or their family or household. I'm going to conclude tonight's session at the end, obviously, with some cases, but I'll just mention one case now where the employer succeeded because the request that the employee made, and the case is called Hutchison and CleanCo Queensland Limited, and the Fair Work Commission refused the request. They said that that request was not closely tied enough to the protected caring circumstance. So in other words, really what they were saying was that the employee said that I'm a carer for a school-aged child and that I need to work more flexibly. But the Fair Work Commission said there wasn't enough evidence. And as these cases show, it's always about the evidence. And also, in addition, the employer proved in addition a genuine operational reasons for the refusal. And again, as I said, we will get to that at the end, and the extra cost that would be involved in complying with the request was also another reason why the Fair Work Commission denied it. But for present purposes, as I said, those reasons that are in that last paragraph on that slide, they have to exist, and they have to show that flexible work is required as a result of those things, not just that the person has a disability, therefore I should be able to work shorter hours or longer hours or work from home at a different location, earlier start times, later start times. It has to be actually tied to the particular established circumstance that are in the last paragraph of that slide. And now I'll get to what are flexible work. So what must the request relate to? Which is a very wide range of arrangements can be sought. They can basically, as I said, relate to any flexible work arrangement. And these are only examples, as we've said in the slide, that changes to start and finish times of work, part-time hours instead of full-time for a period of time, job sharing with a fellow employee, split shifts, so doing a shift, say, for 4 hours, going home for 4 hours, and then coming back and doing another 4 hours, for example. And as I said, working from home or working from a different location. In relation to an issue that sometimes arises, that if a flexible work request is granted, well, how long is it going to be granted for? So there has to be agreement about that. I don't recommend that the employee or the employer allows an arrangement that's going to be forever. It's probably a mix of, say, 3 months or 6 months, and then we'll have a review after the arrangement. That is, obviously, if it's approved. So they're put into place for a period of time for a semi-temporary reason. But even if that's not the case and it's not a temporary reason, they shouldn't be left open-ended and then exist forever. There are some complications with job sharing with a fellow employee, and I also am aware of a case where a person put a flexible work request in, and whilst that was under consideration in the 21-day time limit, another person put another request in, and so the second person then said, well, why should they get precedence just because the first one came first? And so both the employees said to the employer that you should approve both of our requests, so we shouldn't be discriminated against. You shouldn't be allowing the request for employee number 2 and not for number 1, and vice versa. And the employer actually decided, yes, well, that sounds like a fair argument to me. So it can be a complication for an employer if they have one request, then they might get another one, particularly if the employees are talking about that a request has been made. Another employee puts a request in, another employee again puts a request in as well. And so basically the Fair Work Commission has said that it's first comes, first served. So if the first person puts a request in, that has to be considered in isolation to the second one. And then the second one gets considered in isolation, well, not in isolation. So now that the first one has been granted, the second one is then considered, and then 2 and 3 and so forth. As I said, the law relates to changes in working arrangements of a temporary nature. As I said, they shouldn't be left open-ended, and it can cover both hours, location, patterns of work, but the categories are not limited. Parties can agree, if they do agree, or make arrangements on any type of arrangement that they may see fit. The common one, what might be that an earlier start time, such as 7:30, so that the finish time can be 3, so that the people can go and pick up the children, and that would be a protected reason for making a request, having the care of school-aged children. But they can cover anything really, so they might be work from home 3 days a week, work from home 2 days a week, 1 day a week, 4 days a week, and various arrangements and changes like that. On to the next slide, and that is the employer's response. And this is what us lawyers call a procedural requirement. But in this case, cases have been won and lost where the employer has not complied with the procedural requirement, such as responding to the request within the prescribed period of time, 21 days in writing. And ideally, within that 21 days, the employer has a meeting with the employee and discusses it, and then goes away and comes back and says, we've now given you a formal response. And so that discussion and meeting, or discussions, plural, is highly encouraged and is really necessary, because the employer has to consider why the request is being made, and they do need to consider, because a case has been lost where this was not met. They need to consider, well, if the employer refuses the request, how that is going to affect the employee. So if, say, you have an employee who is a carer of a disabled child and they put in a flexible work request, the employer does have to consider, well, if we deny this request, the employee may need to make alternative arrangements for the care of the disabled child, and so that can be quite costly. That type of stuff, though, has to be taken into account. It's not conclusive, but it needs to be considered by the employer. And again, I'll get to the cases where there was one case where the Fair Work Commission was not satisfied that the employer had genuinely considered how a refusal would affect the employee. And for that reason alone, even though there were reasonable business grounds, the Fair Work Commission actually ordered the request to be granted. As it says here, the response must either be to accept the request or to reject it completely, or to propose an alternative that is fairly similar to the request. So, you might say, well, I want to work from home 3 days a week. And so the employer might say, well, on reasonable business grounds, we'll refuse that, but how about, or we propose that you work from home 2 days a week because we want you in the office to talk to colleagues and the like, and attend meetings in person for those other 3 days of the week. As we say there, the work must continue in the business, so it's business as usual whilst the request is under consideration for the 21 days. And that 21 days time limit is a very strict requirement. As I was saying to Carl before we started off tonight, there was a case where the employer responded within 23 days. The Fair Work Commission found that there were reasonable business grounds, but because the employer had not complied with the procedural requirement and missed the response by 2 days, the Fair Work Commission, for that reason, said that we are going to grant the request. So they made an order that the request was granted, even though there were reasonable business grounds for the refusal. And as I said there must be meetings and discussions. The employer must, if they refuse a request, but of course, in addition, if the request is approved, genuinely discuss it. When we say genuinely discuss it, we mean that discuss it with them with a view to genuinely and properly and reasonably coming to an agreement if possible, and genuinely try to reach an agreement. So there is a requirement of good faith in the employer and on the employee too, really. And any refusal must be explained. Verbal explanations are not sufficient. It should be in writing, and mere inconvenience to the employer, such as, well, we'd rather it not be like that, but so we're going to say no, is not sufficient reason for the refusal, which leads us to potentially the area of dispute, or the biggest area for dispute in this area is when an employer refuses a request. So an employer can only refuse a request on reasonable business grounds. And now, obviously, when you use the word reasonable, how long is a piece of string, we often say, and so that's where there is room for negotiation and disagreement or difference of opinion as to what is reasonable. The employer must genuinely try to reach an agreement and discuss the request. They must consider and show that they have considered the impact on the employee of a refusal, as I said. So reasonable business grounds are really practical operational things for the business, such as it's going to negatively impact on customer service. There's no capacity to change around other staff members to accommodate the request. The request just will not work. I guess an extreme example might be there where a person who does only reception duties then says that she wants to work from home 1 day a week. Well, obviously that won't work because you can't do that job, a reception job from home. Efficiency losses for the business, productivity drops, and the size and nature of the business and exactly what it does, how many staff members are there, how many locations, it all depends on the nature of the business, can be a very key consideration. If the matter does go to the Fair Work Commission, so basically what happens is an employee puts the request in, the employer refuses, for example, the employee is not happy about that, they can then apply to the Fair Work Commission for the Commission to assist to resolve the dispute. And at first instance, the Fair Work Commission will generally conciliate, which is really just another word for a mediation. There will be an informal mediation, probably on Microsoft Teams. And if the matter can't be resolved then, and just like any other areas of employment law, Fair Work Commission has very high levels of settlement, then the matter can then proceed beyond conciliation and actually be arbitrated. And an arbitration is, for all intents and purposes, where the Fair Work Commission will actually make an order. The outcome of the matter is out of the parties' hands. They present their evidence, and the Fair Work Commission will make a decision. As we said there, the employee aggrieved can take the matter to the Fair Work Commission, generally hold a conciliation. It can be taken to a hearing where orders can be made. So a Fair Work Commission order is not necessarily enforceable in its own right, but they're highly persuasive, and most parties, particularly are reasonable, will abide by those orders. So I'm just going to finish off today before we get to questions and take you through the latest cases, of which I've extracted 8 of the latest cases. And so we've got, out of those 8 cases, only 2 were decided in favour of the employer and 6 were decided in favour of the employee. So the first one is Naden, N-A-D-E-N. The Fair Work Commission found that the employer did not properly satisfy all the procedural requirements for the refusal, and they, in particular, did not adequately consider the consequences for the employee. I referred to that before, where I said that there was a case where the employees, the consequences for the employee were not considered, and on that basis alone, even though there were reasonable business grounds, the employee succeeded. Then we have a case of Metcash, and I will take you people through these fairly quickly. Metcash, the employee again succeeded. The employer could not prove with evidence the justification on reasonable business grounds. A Kent AOMA versus FLSA Holdings Proprietary Limited. The Fair Work Commission, again, was not convinced by the employer's evidence that there would be a material drop in productivity or customer service, and they rejected the employer's precedent argument where they refused a request previously, and so therefore, on similar grounds, they should refuse this request. Each request needs to be considered in its own right. A case of Anthony May and Paper Australia Proprietary Limited. Again, the employee succeeded. The Fair Work Commission said that, again, there was inadequate evidence of reasonable business grounds set forth by the employer. In Chandler versus Westpac Banking Corporation, again, the employee succeeded on a number of grounds, and against a Westpac, so a large organisation, where they failed to properly engage with the employee as to the request. They missed the response period of 21 days. They again did not adequately consider the consequences for the employee if the request was refused. And they also did not prove by evidence real business grounds for the refusal. We've got another AOMA versus FLSA Holdings Proprietary Limited. The employee succeeded, and the Fair Work Commission was not satisfied by the employer's evidence as to client impact or precedent, and the evidence of harm that would be caused by the request being granted was too thin and did not meet the burden of proof on the balance of probabilities. So that's 6 cases that have been decided in favour of the employee, and I've got 2 cases that were decided in favour of the employer. We've got Hutchison and CleanCo Queensland Limited. The request was not closely tied, I've already mentioned that one before. The request was not closely tied enough to the protected caring circumstance, and the employer did actually provide evidence of genuine operational difficulty and an extra cost on the business if the request was granted. And the last case is Grayson, G-R-A-T-I-O-N, and Bendigo Bank. The employer succeeded because the evidence did not show that permanent remote work, which was what was requested, was necessary to actually meet the employee's caring responsibilities. So the employee basically failed to provide evidence that the request had to be made so that the employee could meet their caring in their carer family responsibilities. So that goes to show that I was talking to Carl before about that when I decided to extract the last eight cases, I actually thought it would be the other way around, and I thought we would have 6 in favour of the employer and 2 in favour of the employee, and I justified that by basically saying, well, probably with most of these cases, the employee is not getting legal representation, and the employer is, and therefore the employer is likely to be winning those cases. And I don't know out of those cases who was represented and who was not. But as I said, it was a 6-2 in favour of the employee, and I expect it to be 6-2 in favour of the employer. So very interesting area of law, and I think it's a lesson for employers that they need to follow the procedural requirements, such as 21 days, the request being in writing, have to genuinely consider the effect on the employee of a refusal, and they have to actually provide genuine evidence that shows that there is some productivity or efficiency losses, and not just state the bald facts, but they needed to show credible evidence in writing and or by oral evidence to convince the Fair Work Commission that there will be a genuine impact on the business under the category of reasonable business grounds. And that concludes my presentation. Thanks, Carl.
Thanks, Paul. They're very insightful, and I think it's an area of sort of employment relations that I think is changing given the pandemic that we had a few years ago, and the shift in expectation around you can also work from other places rather than just working from home. But I guess there still needs to be a sort of thought given to what the impact might be on the business, on the employer. But it looks like the Fair Work Commission is entertaining the request from employees and looking to sort of support their request to work flexibly. Before we proceed to Q&A, I'll just share Paul's details on screen. So we've got Paul's details there. So if you do have any specific queries for Paul, please do reach out to him directly. Just a reminder, the session is being recorded, so if you do have any questions or if you've had to sort of drop off early, you can always watch the entire session on our YouTube channel later today. And Paul has also kindly prepared a one-page handout, which I'll share with registered participants following today's session by email. So Paul, we'll just get straight into Q&A, because we've actually got quite a few questions that I want to go through.
Yeah.
The first one is, I think you've touched on a few of them, right? And I think by sharing those cases at the end, you've actually sort of contextualized, I guess, the Fair Work Commission's view on these types of requests. But what's sort of your view? Like, you've been a practicing lawyer in the employment space for a while now. Are you genuinely seeing an overall shift in these requests being considered genuinely by employers, or do you still see cases coming through where employers are being a bit conservative, and then the employee, I guess, pushes forward a bit with escalating it to the commission through conciliation and arbitration, and then the employer, I guess, sees a bit of reason in the request? Like, is there a shift that you're seeing in the relationship there?
I don't know whether there's a shift so much, but the Fair Work Act and the Fair Work Commission is at all times, even though some people may differ in their opinion on this, is that it's always trying to strike a balance, a 50-50 balance between the employers and the employee, and do the best they can. I think because the area is relatively new, employers are not really up to speed 100% as to this area of law. It's pretty new. And as I said to you before we started, if this session tonight had happened a year ago, there might have been one or two cases that we could have looked at that I could have referred to. There was none. And I had a case where we had a mediation with a Fair Work Commissioner, and he said that it's just too early. And this is about a year ago, maybe a little bit more. He said it's just too early to decide for me to tell you, as a reality test of your client's position. It's too early to say how it would be decided because there's no case law. So now we're lucky that we do have some case law, and so we're aware of the things to be really looking out for. And the things that employers need to look out for have got commonalities, such as reaching the 21-day time limit deadline, genuinely considering the offer and not just dismissing it out of hand, and having reasoning around it, and having reasoning that does actually show that the employer considered the impact of a refusal. If they just go off and blindly say, well, we've got reasonable business grounds, which may well exist, and prove that there are reasonable business grounds, but if there's no evidence showing that in the request refusal the employer did not consider how it would impact on the employee, then it's likely that the employee will win.
Yeah, so with that, Paul, I think there's one question that I want to just raise is around, like, what's the expectation on, like, the people team or the HR team within an organization to, aside from evaluating reasonable business grounds, which is sort of the employer's, I guess, view on the request, but how deep do these teams need to go into assessing the employee's concerns, right? Like, it might be disability, or it might be age, or it might be caring circumstances, and sort of considering the impact on
Yeah.
the employee. Is it almost like they have to adopt additional sort of roles around, understanding these typical nuances, understanding health-related issues? Our ordinary sort of HR staff, people staff, sort of equipped to be able to make those assessments? What are your sort of thoughts on that?
Well, that's a very good question as to whether HR departments, no disrespect, of course, are fit to consider these things. But I don't think that employers or HR departments need to be particularly worried about or scared about these things. And they don't need to, I don't think, need to go into a huge amount of detail about what the attribute is, only in that they need to consider that for the employee to meet those responsibilities, what has to happen for the
Mm,
employee in their life. To pick up school-aged children when there's nobody else to do it, and there's no other way for those kids to get home at 3:30. If the refusal is that no, you have to work till 5, well, that's a difficult one, and I don't know the solution off the top of my head when I give you an example like that.
mm,
But I don't think that employers need to be particularly worried. I think it's not really a genuine concern that this line of cases that most employees win is going to stay like that. I think that once people come to grips with the law, and not only what the law says, but which I've talked about today, but how it operates in practice is a different thing altogether. It's one thing to say that the law exists, but there's also its application. That's the key thing about it. I think things will change in time and employers will become better at it. And I think that at the moment they're just not quite up to speed with it all, which is perfectly normal with any area of law. I mean, if a year ago a Fair Work Commission member said he
mm.
doesn't know what the law would have been or how it would be held, then how's an employer supposed to do it when they're still coming to grips with this?
Yeah. Just a question that's probably from an employer's perspective. Paul, we speak about some of the circumstances, right, that would give rise to a request to be made, like what they
Yeah,
must relate to. What's the onus on the employee to ensure that, of course, they'll be stating the truth and in good faith, right? They're not sort of making it up. But then, say for example, they do need to care for a child that needs to be picked up at 3:30, and that might occur for, like, maybe 4 months or 5 months because the partner might be away or might be particular circumstances. But if those circumstances change back to what it was normally, there's a sort of an obligation on the employee to sort of come back and sort of say, look, I no longer need this flexible work arrangement, or is there sort of a gap there in sort of that cycle, that loop, to ensure that employees are not sort of just taking the benefit of this for the long term, when that circumstance is no longer relevant. So is
well,
there?
that's right. I mean,
Mm,
that's a very good question because it relates to what I said before, where
mm,
if a request is granted, there should be a time limit on them,
yeah,
and the conversation should happen from the employer to say, well, how long is this arrangement going to be needed for?
yeah,
And of course, there's going to be some times when the employee will say, well, I don't know, but
mm,
I think that employers probably need to be proactive and
correct.
say every 3 months or every 6 months, go back to the employer and say, hey, do you still need this arrangement?
Mm,
So it's not a set and forget for the employee or for the employer. But I don't think there's necessarily an onus on the employee to go back and say, hey, I don't need it anymore. But I
mm,
think there is an onus on the employer to check with the employee.
yeah,
I think both parties need to not treat it as a set and forget, even if there is a time limit, because there might be a time limit given for 12 months, but it might be that something changes before the 12 months is up. But I don't think that there's necessarily an onus or a legal requirement on either party.
mm,
It's just going to really be a play it by ear and play it along. But I think that even if there is a time limit, there should be a regular review of it, and that should hopefully pick up most cases when there's been some sort of change in arrangements.
yeah. And just to clarify, Paul, we just had one question around those sort of circumstances that the request must relate to. They're an exhaustive list, right? There isn't any sort of catch-all or any other sort of general circumstance that could be considered. It has to relate to those matters that you described
Yeah,
earlier.
it
Yeah,
has to relate to those matters only. I mean, they're listed in the legislation itself. So it has to relate to those things. Yeah.
right.
I mean, if someone really genuinely needs flexible work and it doesn't relate to any of those things, then as I said, a request can still be made, but it won't
have to
be
protect.
under this regime. Also,
Yeah.
I think it's also important as well that
Mm.
just going back quickly to employers, they need to be aware, which I'm sure most of them are, that the discrimination laws sit in the background to all this. So if,
Mm.
for example, an employee made a request for caring responsibilities and it was denied, they do need to be mindful that the employee could then say, well, I exercise a workplace right to make a request. And because I exercise that workplace right, you're denying the request. Therefore, you've taken unlawful adverse action against me. So there hasn't been any cases where that's happened yet, but that is a risk for employers. But what that comes down to is that what was the reason in the employer's mind when they made the decision to deny the request? If it's well, we believe that operationally it wouldn't work, then the employer's fine. But if it's, well, you've got caring responsibilities and that inconveniences the business, and they don't even need to say that. If that's in their mind, there is a reverse onus of proof in the employer. The employee can make the allegation, and the law presumes, because of that reverse onus of proof, that the employer did it for the discriminatory reason. And so that helps the employee. So the discrimination laws do sit in the background here.
Just on that point, Paul, as an extension of that, just talking about laws that sit in the background, there's also that the sort of that regime that started last year about the psychological risk, right? And there's sort of an onus on employees as well to sort of minimize that risk from perpetuating.
Yeah,
Is sort of an interconnection here at play that, if the employer doesn't sort of grant a reasonable work request based on what the law says, and acts a bit funny in that respect, and then triggers puts that employer under additional stress and pressure. Could there also sort of be a link there in the background to the employer not sort of taking care
yeah,
from that psychological perspective?
yeah, definitely. Because like most areas of law in employment or other areas of law too, I would say is that they do interlink, and so employers are now subject to positive duty, so they actually need to not just be mindful of psychosocial hazards, they actually have to take positive steps to prevent them and deal with them if they
Mm,
come about. And so if it is a psychosocial hazard that an employee is really stressed out because they have to rush home from work to go and pick up their children, if that becomes a psychosocial hazard, that the employee says that you didn't take positive steps because you denied my request for
mm,
flexible work,
mm,
then that's a complicated issue that the Fair Work Commission is a body very well equipped to untangle it.
mm.
But again, those psychosocial hazards and the new positive duty, which started in December last year, do sit in the background of this area of law as well.
Yeah. So definitely, of course, there's all these laws are operating parallel and
Yeah,
shouldn't be considered in isolation. There's no sort of defense, to any of the other laws that you've sort of considered on reasonable business grounds and can sort of, mitigate compliance with those laws. They still all apply.
yeah,
Paul, just on that point, had a question just in relation to, say, for example, someone wants to seek employment at a particular organization, and before they get accepted that employment position, right?
yeah.
They also request a flexible work arrangement. Does the regimes apply to those that are not currently employees, that they're prospective and are wanting to do that part of the application process, or do you have to have been accepted as an employee and then have served those 12 months? I guess is
Yeah.
that's probably the rules, and I think I've just answered my question, but yeah.
It is a strict eligibility requirement,
Yeah,
but don't forget though that, as I said, those
yeah,
discrimination laws sit there in the background.
yeah.
And if a person wasn't employed because they got carer responsibilities, well, that can still be illegal discrimination. You can take it
Mm,
to the Fair Work Commission or to the
yeah,
Victorian Human Rights and Equal Opportunities Commission or the Commonwealth body too.
yeah, yeah. So yeah, that's right. So just to the person that asked that question, that you have to have served at least 12 months employment and had a sort of regular pattern of work to be eligible for this regime. Of course, as you said, Paul, it doesn't stop you from making the informal request. You just want to have that protection. and also doesn't bar the employer from complying with those discrimination.
Yeah. I mean,
Okay.
that's a good point that was,
Yeah.
sorry, it was a good point that was raised because prospective employees, a
Mm,
lot of people might think that, oh, well, I'm not an employee yet, but so I'm being interviewed or I'm about to start or
mm,
whatever.
mm,
They do actually have legal protections at times almost similar to a currently serving employee. So that's a good point that prospective employees do have some protections, such as from misleading deceptive conduct
mm,
and also from unlawful deductions from pay, or where the
mm,
employer says that in onboarding you, we incurred some costs and therefore you've got to pay for them. Well, there's a section of the Fair Work Act 325 1A that
mm,
says that a prospective employee, sorry, cannot be required to pay or spend money to a prospective employer
mm.
um, in those circumstances where the amount's unreasonable and where it's for the employer's benefit.
Yeah. And actually, Paul, you just touched on a point. I think this question is actually taking a nice turn because I mean, you just touched on a point that I want to raise with you, which is, so for example, the request comes through, they meet the eligibility requirements, it relates to a listed circumstance,
Yeah.
and the employer says, yeah, fine, okay, we'll look into it, and I think we'll grant it, but on the basis that we adjust your benefits and your entitlements. Is that something the employer can do, or that could that trigger other problems for the employer if they start sort of lowering pay or removing certain entitlements because they want to, they're accommodating that flexible work request on the basis that it's something they're probably going to incur costs in doing so. Can the employer sort of exercise those sort of options?
Well, generally no, but
Mm,
if part of a flexible work request is that an employee works instead of 40 hours, they work 30 hours, well, they're going to
mm,
be paid less. And I think
mm, mm, mm,
there will be that allowance. Also,
mm,
the parties need to consult the employment contracts. A lot of employers will reserve the right to change position, title, and duties and tasks unilaterally without the employee's consent. There's often a clause in the contract that says that they can do that. But
mm,
if there isn't a clause like that, then the employer cannot just change those things. And if by also the danger with that is that if the employer did change terms and conditions and made the pay less, well, that's probably adverse action that could
mm,
be subject to a general protections claim. In
mm.
other words, taking unlawful adverse action for a prohibited reason, which is exercising your workplace right to make a flexible work request. So there's a lot of danger in that one, and there's a few little issues that feed into that type of situation, and that it might happen.
Yeah,
It probably will happen in time. It's just a matter of when things like that will pop up.
definitely. Yeah, yeah. This is all, as you said, it's all fairly new, and it's it's sort of just going through the motions of cases actually being heard and decisions being made.
Yeah,
So it's an evolving space.
it is, and
Paul,
it's early days.
yeah, it's early days. Paul, just do you have any reflections just on where this position might go in the future? Like, do you have any sort of inkling as to whether it might get more flexible? Do you think it'll add more circumstances, or is everything pretty much just set in stone for now? Like, do you foresee any additional circumstances being added to that list that potentially might support a flexible
So,
rest, or
well,
you know,
most of those cases are really only really been about flexible work requests only.
mm,
I foresee that just as what we talked about, cases will come along where there are some of the other areas of law intersecting with it and coming along.
mm,
And I think that last example you gave me is a very pertinent one where the employer will say, well, your flexible work request is granted. You're now on part time, and we're going to pay you less, and
mm,
we're going to drop you in seniority. And so I think there'll be cases where, rather than these cases reaching the commission for just a flexible work request, there'll be other legal issues and other areas of employment law intersecting it, such as discrimination and general protections and that type of thing. I think that's what will happen, is that cases will get bigger and more complicated and showing other issues besides just the refusal. And the other
totally.
thing is too, now it's very early days. For
Mm,
example, the unfair dismissal jurisdiction has been around for about 30 years.
mm,
This area of law has been around for about two. So there's
mm,
going to
mm.
be a lot of developments over time.
Exactly right, and it's say for example that person did want to drop down to part time, and they're like one FT, and then they want to become 0.6, so they're doing sort of 3 out of the
Yeah,
5 days, and then the backfill has to occur for those extra 2 days, and then after a year's time, the employer might say, well, there is actually no role to fill because that other person has taken the 2 days, and so it actually might lead to other sort of issues, and then the redundancy might trigger
yeah,
because
that's right.
then you have sort of those issues to think about. So, but it's definitely a regime that's helpful in the current economic climate. But you know, I think you sort of said at the start, Paul, that there needs to be a balancing of considerations, right? It can't just be pro-employee or pro-employer. It needs to sort of consider both sides because you are going to have organizational, operational considerations that need to be factored in. Otherwise, you're just going to trigger other problems down the line when, as you say, the other laws sort of intersect with this and I guess broaden and widen the issues that need to be considered. So,
And just one last comment. I think
mm,
that even
mm,
though obviously the COVID years, so to speak, were horrendous, this is, I think, the flexible work request regime that's, to me, has resulted from it in that recognising, whereas 10 years ago, there was no such thing as a flexible work request, and it
correct.
certainly wasn't a legally protected right. And
Mm,
so the world of work is changing, and a lot of that's been precipitated by COVID. And working from home was a thing, really, or was a very minor thing. And
correct.
now we're going full circle in Victoria, and the government's legislating for a right to work from home in some circumstances. So
Mm,
anyway, so I think this regime is one other thing that has been positive that's come out of COVID years, even though there was a lot of negativity.
correct. Yeah. Yeah. Definitely. I think it's just sort of added another perspective to how work arrangements can actually operationalize in practice, and still doesn't always lead to lower productivity. There are some benefits to be gained. So, no, well said, Paul. That brings us to a
Yeah,
close of Q&A. I'll just share Paul's details on the screen. If you do have any specific questions relating to your circumstances, please do reach out to him. He'll be more than happy to take your call. Other than that, that brings us to the end of the session. Thank you for joining us at a Be Informed session. Today's entire session has been recorded, so if you have joined late, you can watch the entire session on YouTube later today. And there's a one-page handout which I'll be sending through to registered participants by email, so you'll have that handy for yourself, or you can share with family and friends as you wish. If you have found this session enjoyable, you've learned something, you think it will be useful for others, please do follow us on social media and share it with others. Our sole goal is just to make you better informed, so your decisions are, taken with information that will support you on your journey. So that brings us to the end. Again, thank you, Paul, for your time. As always, friend of Be
thanks,
Informed,
Carl.
and we really appreciate your support. And thank you to those who joined today. And bye for now. Thank you.
Thank you. See you later, everybody.